So, without further ado, the class action mechanism. Class action, simple idea. A lot of people have been harmed in a relatively small way, probably not worth the expense and trouble to them to bring a lawsuit on their own. The class action brings them all together and allows one law firm to represent the class and to pursue recovery on their behalf. Okay? And we use class actions in a variety of contexts, personal injuries due to asbestos, tobacco, etc. But we also use them in the securities context as a way of dealing with securities fraud. And I think most people would agree that there are two principal goals for anti-fraud provisions. And the first is deterrence. We want to sanction people who engage in fraud because we would like to discourage others from doing the same. Okay? And the implication for the securities markets, we generally expect people to be inflating the price of these securities through misrepresentations. On rare occasion, they will be bad-mouthing the securities because they want to buy them on the cheap. But typically, it's hype, right? It's hype and it's fraudulent hype. So that means the securities are going to be overpriced. Insofar as investors don't know which companies are committing fraud and which companies aren't, if they knew, they obviously wouldn't buy the fraudulent securities. They're going to reduce the amount that they're willing to pay for securities generally. It's the fraud discount, okay? And that's a real tax on honest companies, right? Because they're getting this discount when they sell securities because investors don't know whether or not they're an honest company. So that's a real tax on doing business for honest companies. Honest companies would like fraudulent companies to be sanctioned, right? So that investors could sort the good from the bad and there would be less discounting for the possibility of fraud. And the deterrence provided by securities fraud class actions, private lawsuits, the SEC has repeatedly said, is an important supplement to the deterrent effect that SEC enforcement actions, Department of Justice criminal actions have in discouraging fraud. So the way of thinking about the deterrence of securities fraud class actions is the marginal deterrence. How much additional deterrence do we get from having securities class actions above and beyond what we already get from government enforcement, and what's the value of that deterrence relative to the costs that we have to pay for it. The other goal, and that's going to be my main focus here, is compensation. All right? The argument is that if investors are not compensated when they are defrauded, they're going to stay away. They're going to put their money under the mattress at home, or more likely they're going to put it in a safe deposit account or a CD. So the notion is that compensation will encourage investor participation in the securities markets. That's good for capital formation and investment. That's good for economic growth. All right? That's the basic idea. All right. Our main anti-fraud provision is Rule 10b-5, and it has a number of elements to it, and I'm just going to breeze through most of these. I want to focus on just a couple. Material, the information that's misstated has to be something that was important to a reasonable investor. It can be either a misrepresentation, an affirmative lie, or you've left out something that is necessary to give us the complete picture. Scienter, that's legal talk for a fraudulent state of mind. You either knew that what you were saying was false, or you recklessly didn't care whether or not it was true. And the reason we include this requirement is that we don't want to chill speech by sanctioning innocent mistakes. All right? One response to a lower standard would be that corporations and their officers would just shut up. They would disclose what was required by the SEC and nothing more. So we wouldn't have earnings forecasts, we wouldn't have press releases, any of the information flow from corporations that helps inform the stock market price. Reliance, simple idea. Your misstatement caused me to buy the security, right? If you hadn't lied to me, I would not have purchased the security, or I would have purchased the security at a different price. I would not have paid as much as I did. Causation. If a fraud falls in the woods and nobody hears it, is it really a fraud? There has to be some implication of the fraud. It has to show up in the stock price at some point. If the company commits fraud, overstates its revenues, and boosts its stock price up, and then is destroyed in a hurricane, okay, the loss is not caused by the fraud, and investors can't recover for that. And then damages. Here, the measure of damages in securities fraud lawsuits is key, because the measure we use is the difference between the price that the investor paid and the value of that security if there had been no misrepresentation. So that's the fraud ribbon, the people who do this work call it, the difference between the value of the security and the price of the security. A couple other requirements, interstate commerce, that's not important. The transactional nexus, in connection with the purchase or sale. And here, this is the language from Rule 10b-5, and the language is actually important here because the language is in connection with the purchase or sale, not in the purchase or sale of security. What that means is that you do not have to have bought or sold a security to have committed a Rule 10b-5 fraud violation. As long as your misrepresentation affected the security's price, you can be held responsible for that fraud, whether or not you were selling securities. Okay? And I have a helpful picture to try and sort out the distinction here. Two kinds of fraud that we call primary market fraud and secondary market fraud. In both cases, the company has overstated its profits. Okay, so it's caused people to think that its securities are more valuable than they are, right? Because investors are very interested in profits. And in our first scenario, the company sells 10 million shares to the investing public. Okay, so all of those investors have paid too much for those securities, and the issuer has received too much. The harm to the investors pretty much directly equates to the benefit to the issuer of having committed the fraud. Here's the situation where compensation makes a lot of sense, because we know from a deterrent perspective that we want fraud to not pay. And in order for fraud to not pay, we have to take away all of the unjust gain from the company, right? They fraudulently inflated the price of their securities and they got more than they should have. We want to take that away from them to send a message to them and other companies not to do that, all right? That's primary market fraud, and that is an important class of securities class actions, but by no means the predominant form. Maybe 20% of securities class actions involve primary offerings where the company is selling securities to the public. Most securities class actions involve transactions where investors have sold to other investors. Okay? So outside investors with no connection to the company are selling the securities. These transactions are all affected by the fraud that the company was committing, right? The price of these secondary market transactions is influenced by the overstatement of profits by the company. Once again, the harm to the investors who purchased, they've paid too much, is pretty much exactly equal to the benefit to the investors who sold. The difference is that these investors who've sold haven't committed fraud. They've done nothing wrong. It's the company that overstated the profits. They probably had no idea that they were getting more for their shares than they should have. Okay? So here, culpability for the fraud does not line up with benefit from the fraud in the way that it did in the first situation where the company was selling shares. Exactly equal, the benefit to the harm, despite the fact that the corporation has not benefited from the fraud in this case. It's not selling the securities. It is liable for all of the harm to these people. There is no offset for the benefit to the shareholders who sold at too high a price. All right? So from an investor wealth perspective, investors are not really much worse off as a result of this fraud. There's some distribution among the investors in terms of these people who sold are a little bit wealthier and the people who bought are a little bit less, but the aggregate wealth of investors is not really affected. Nonetheless, we have a cause of action that allows full recovery, at least in theory, for the people who were on the losing side of these transactions. Okay? So that's the basic setup of the secondary market class action, is compensating all of these people for the harm that they suffered. Securities class actions start to become big business after 1987, which is when the U.S. Supreme Court really opened the door to secondary market class actions. This is some technical litigator stuff, but basically the reliance requirement of 10b-5, you have to have heard the misstatement and it caused you to enter into the transaction, is in conflict with a federal rule of civil procedure, the rules for bringing cases in federal court, that requires common questions of fact to bring things as a class action. So the question would be, did you 5 million people who bought this company's securities, did you all hear the misstatement of the overstated profits, for example? All right? And obviously, we're not going to have a judicial proceeding where we ask all 5 million of those people whether or not they heard that misstatement and entered into the transaction. And in fact, very few of them did. Okay? Most investors are not reading the press releases and the 10Ks and the 10Qs. Professional investors are. Institutional investors like mutual funds, insurance companies, banks are. But most people are not. They're simply buying the securities, relying on the price. So what the Supreme Court said was, if you bought a security that was affected, the price of which was affected by fraud in the market incorporates all of the information available to it, good and bad, garbage in, garbage out is the basic idea. And as a result, the stock price is inflated by that. We're going to treat that as reliance. You don't have to have heard this misstatement that allegedly distorted the securities price in order to recover. We will assume if it's a stock that is traded in an active stock market, a liquid market that rapidly incorporates information, that's going to be sufficient. One implication of this is that in order to bring a class action, the plaintiff's lawyers who are choosing the cases to bring are going to look for large companies with a lot of securities trading, because those are the cases where they can bring this type of action. That's meaningless one way or the other standing on its own, except when we think about it from a deterrence perspective. If this device is causing us to focus on the big companies and necessarily ignore the smaller companies, that's just backwards from a deterrence perspective. We know that smaller companies are more likely to commit fraud because smaller companies don't have the resources to pay for expensive auditors, don't have the resources to pay for elaborate internal controls, internal audit functions that discourage fraud. So the likelihood of fraud is much greater for smaller companies, but the class action is targeted at the larger ones. Okay? So with this reliance set up, where you don't have to actually hear the misstatements in order to recover, we basically have set up a compensation scheme for people who have purchased securities that has been influenced by fraud. And one way of thinking about this is an insurance policy, right? Bad things happen to you. You might want to buy an insurance policy to ameliorate the loss, right? Your car gets totaled. That's going to be a real problem for you if you don't have an extra $20,000 lying around to go buy a new car. You'd like insurance to take away the sting of it. So the open market class action promises compensation for your loss from fraud. All right, we're going to take the sting out of your loss from fraud. The problem with it is that it's not cheap. We're paying a lot of money to pay out this compensation. And critically, the money is all coming from the shareholders. The damages in these cases are paid by either the corporation or the insurance policy that the corporation pays for. The shareholders are the residual claimants of the corporation, so that money to pay the damages and to pay the insurance is coming from them. So shareholders are taking money out of one pocket, and they're going to shift it to another. But first, no, not quite enough. Yeah. There are lawyers in the room here, aren't there? Yeah, why weren't you diving for that? That's your money. That's the money that goes to the lawyers, right? 50 cents on the dollar is going to the lawyers, both the plaintiff's lawyers that we have to pay for bringing the action. It was a 1. It was not a 10 or a 20, in case you were wondering. We have to pay the plaintiff's lawyers for bringing the cause of action, and they're going to get maybe 25% of the recovery that they get for the class. But the corporation is also paying for the defense attorneys. And they're billing out at $500, $600, $700 an hour. And in a complicated securities class action, they are putting in hundreds, thousands of hours to defend the case. Okay? And this is so we can transfer money from one group of shareholders, the existing shareholders of the company, to another group of shareholders, the ones who purchased during the period of the fraud. And frequently, that group is going to overlap, right? If you bought the securities during the period of the fraud and you continue to hold them, you're going to be paying yourself through the mechanism of the securities fraud class action, but you're going to be paying yourself after you've paid the lawyers and forensic accountants and all of those people a lot of money. So it's a very inefficient form of insurance policy, but that's okay because it doesn't provide much compensation either. All right? We're only going to pay you 2% to 10% of your losses. So you paid $100 for the security. The price was inflated by $30 per share. Your loss is $30 per share. We're going to give you, at most, $3 a share in recovery. All right? So as a form of insurance, it's pathetic, to be honest. The state insurance administrators would not let you sell this policy. Clarification question?
Yes, you said 2 to 10%, but what is the median value? Because I expect that 10% is quite high.
The median is about 2. Okay. So the alternative to this insurance policy that you pay a lot of money for and provides you with dismal compensation is self-insurance, right? That the best way to eliminate having significant losses from being an investor in a company that is affected by fraud is to buy a lot of companies, okay? If you buy a lot of companies, if you're well diversified, sometimes you're going to be on the losing end of the fraud because you will have purchased when the price was too high. But other times, you will be on the winning end of the fraud because you will have sold when the price was too high. And your expectation is it's about a wash, right? That the two are going to balance out, right? There's no reason to think that you will be more frequently a winner than a loser in these fraudulently affected transactions. And if you are fully diversified, you should be able to reduce your uncompensated losses to a trivial percentage, and we don't have to pay the lawyers, right? You do have to pay your mutual fund administrator, and I believe that I am paying for my Vanguard index fund somewhere about 6 basis points on the dollar, right? A rounding error. It is so inexpensive to diversify your investments that no one takes that cost into account because it is so trivial. So, the revised version of the goals of securities anti-fraud provisions. We'd like to deter fraud, right? We still think that that's got to be true. Accurate share prices are good for the economy. We'd like to encourage people to participate in the securities markets and make capital cheaper for companies that want to grow. Encourage reliance. We want to encourage people to read those press releases that the companies are putting out and act on them, because that's going to help make the securities markets more accurate. The investors will drive the price to where it should be based on the company's prospects if they can take the information and use it with confidence. That's worthwhile. Compensation? No, it doesn't make sense for almost everyone. It may make sense for those people who are actually reading what the company is saying, investing their time and effort into looking at what the company's statements are and trying to process that. We want to encourage them to do that, but that is the small minority of investors. Okay? So, we have a system that's set up to promote these goals. The damages measure is set up to do the last one, compensation. It is set up at the level required to compensate the people who have been harmed, ignoring the benefits to the people who have gained from the fraud. What that means is that the typical securities fraud class action, the stakes of winning or losing are going to be measured not in the millions of dollars, but almost always in the hundreds of millions of dollars, because we have very active securities markets where lots of people are buying and selling shares, and not infrequently in the billions of dollars, which is a lot of money even for a large corporation. So, if you are the CEO of a company that's been sued in a securities fraud class actions, one of the issues that you got to worry about is we don't think we committed fraud. We think we did everything right. Business didn't turn out well. We had a bad turn in the stock market when we disclosed that. Is the jury going to see it that way? Will they recognize that we didn't have any intention of committing fraud? So there is some chance of error, that the jury won't get it right. And do we want to gamble on the jury getting it right, given that we might have to write a check for $3 billion if we guess wrong? And the answer is no. We don't want to gamble. No one wants to gamble. No one takes these cases to trial. This is not hyperbole. No one ever takes these cases to trial. They always settle because there is settlement value in avoiding going to trial and taking that chance. There's settlement value in not having to pay the lawyers anymore. And there's settlement value in not having your executives sit through depositions, being grilled by plaintiffs' attorneys, and not having to produce documents in discovery. Okay? If you're an outside party that might get sued here, the risk of mistake by a jury is also very substantial. There's this big fraud that's occurred at this company. The auditors must have known. And they're the last deep pocket left that has the ability to pay damages because the corporation went bankrupt, and we might stick it to them because they must have known. Confirmation bias. we know about these companies and the bad guys who are in them, because you remember Enron, don't you? And now here's a company accused of fraud. I'm inclined to believe that as the jury. So all of this drives people to settle securities class actions. Okay? So our next stop is the reforms that Congress has already adopted. And this is 1995 that Congress adopted the Private Securities Litigation Reform Act. And the central finding was the lure of these big damages and the settlement threat that they created was encouraging companies to be sued frivolous lawsuits, and that hurt both the companies and their investors, right? Because the investors ultimately are the ones paying for these class actions. So Congress made it tougher to bring securities fraud class actions. They didn't change the damages measure, right? The part of the cause of action that is driving all of this, they didn't change that. They just put in procedures to make it harder to bring the cases. So if you are making a projection about the company's future, that gets protection from a safe harbor. We have to be quite specific about the who, why, when, where of the fraud. And we won't let the plaintiff's lawyers wade through the company's books and records to try and find the fraud unless a judge says that there really is a case here. A variety of other provisions included to try and make plaintiffs' lawyers more accountable to the shareholders that they were supposed to be representing, and perhaps reduce the size of attorneys' fees. These actually have had some effect. The size of the fees paid to class actions attorneys probably was in the 30 to 33% range before the act was passed, and is now probably more like 20 to 25% of the recovery for the class. So that's a good deal. So the law cracks down on class actions, makes them harder to bring. All right. So what's the response? I love this picture in my line of work, and it's once again topical. The one on your left is familiar to you, I assume. The one on the right, that's extra for experts. He is the one in this picture who is going to jail, which 10 years ago would have been a surprise. That's Bill Larack, who was the most feared man in corporate America because he is an excellent attorney and probably the leading member of the private class action bar. He just pled out an indictment this last week. So, in any event, the history of the PSLRA, Bill Clinton vetoed the act, and then Congress very quickly overrode it. The stock market reacted positively. There's a positive stock market reaction to the override of the veto. This is significant because this is an assessment of investors as to whether or not these restrictions on class actions were going to be good for investors, right? Investors are paying for the class actions. They're the ones who are supposed to be receiving the compensation. This is a big restriction on how class actions work. The reaction of investors is, well, that's good. We're better off, okay? The Ninth Circuit put down a very demanding, tough standard for these kind of suits, and the reaction to that, positive. Investors thought that that was a good thing for them. On the ground, the number of lawsuits hasn't really declined as a result of this law. There has been more forward-looking disclosure, so there's more information available to the stock market. Big change has been a shift in what kind of lawsuits are brought. More lawsuits based on accounting violations, restatements, more on the basis of insider trading. The executives were selling out the stock at the time that we have alleged these misrepresentations were occurring. That shows they knew that there was fraud. A lot of those allegations, they are, however, pretty easy to make. Given the prevalence of stock options as a form of compensation, you can make insider trading allegations against almost any company, and judges seem to have caught on to that. Here's the big restriction. You have to show that the defendant had a fraudulent state of mind, and you have to show it at the time you file your complaint in the case. The first document you file in the case before you have any access to the books and records of the company or to the officers of the company. You have to show that they either knew that they were making a projection that was false or they were reckless, really, really negligent in making a misstatement about a historical fact. What were the revenues from last quarter? Okay? So, I've done a bit of empirical work with some co-authors about what effect did this have on class actions. And one hypothesis is it makes it tougher to bring class actions. You'll want to have a higher pot of money at the end to make it worth your while to bring that suit, right? Because your probability of recovery is lower now, and therefore we need a bigger reward to make it worth your time. You're going to want to have hard evidence of fraud and SEC enforcement action against the company. It doesn't take a rocket scientist to know there maybe is money to be made in a class action if the SEC has done the investigation and has shown that there's a likelihood of fraud here, right? At that point, it's just a matter of sorting out the damages. A restatement of earnings. The company has said, yeah, our earnings were incorrect for the last 2 years. We're sorry about that. We're going to go back and fix it. That is a pretty salient event. It's an admission that you had a material misstatement, the key element that you need to prove. And that's going to have also an effect on the amount of the settlement that gets paid. So my co-authors and I took a bunch of companies that got sued before 1995, and then a bunch of companies that got sued after 1995, and we matched them up with similar companies that didn't get sued. And then the goal is to compare the characteristics of companies that get sued after with the characteristics of companies that got sued before. And what we find out is size matters. You got to have a lot of money at stake in order to bring the class action after we put these restrictions on them. So more than double in the potential damages available from the class action. Who gets sued? What drives plaintiffs' lawyers to bring the suits? Before the PSLRA, market capitalization, the size of the company, how much value it had, was an important determinant. A restatement, unusually high insider trading, making a positive forecast, or warning about earnings. Afterwards, still market capitalization, still a big stock price drop is an important determinant, but also these other factors. And those are more important. So damages numbers, the size of the pot available, became more important after the PSLRA. A larger focus, more of a focus on large companies with big stock price drops, but also factors that maybe arguably are more related to fraud. Companies restated its earnings, or the insiders are selling out, became more important. Earnings warning, which used to be a trigger for a stock price suit that we weren't going to meet our earnings expectations for the quarter, that's less of an influence. So that's probably good news. Just a snapshot of how the allegations change after the PSLRA, accounting and insider trading way up, forecasting down slightly. And then here's the big spike. So this is taking our sample of firms that were sued before the PSLRA. About 9% of them had this hard evidence of fraud, an SEC enforcement action or a restatement of their earnings or revenues. And compared to the companies that we matched them with, more than double, right? So there's a high incidence of restatements and SEC enforcement actions in these companies. After the PSLRA, hard evidence goes through the roof. 25% of these companies had an SEC enforcement action or a restatement, some slight increase for the matched firms. So there are more restatements generally. But plaintiffs' lawyers are clearly focusing much more on restatements and SEC enforcement actions after the PSLRA. Real tangible evidence that the company has committed fraud. So, yes, we need more to get us to file suit. Yes, we expect We need to have more hard evidence that the company has engaged in fraud, and that does have a significant effect on the outcomes. The settlements are larger if you have that hard evidence of fraud. So, the conclusion is the definition of merit has changed. The question is whether that reduces deterrence. So, the claims that don't get brought, right, it's hard to know what they are. They're the claims lacking hard evidence without an SEC enforcement action, without a restatement. We don't know whether those are actions that had merit, where there actually was fraud. It's hard to assess the suits that are not being brought. The suits that are being brought, based on restatements, based on SEC enforcement actions, we're fairly confident that those companies have engaged in fraud, that there is some serious wrongdoing here. But remember, our question is not the deterrent value of these class actions, but the marginal deterrent value. What is the extra deterrent value? And unfortunately, these are good companies to be targeting, but the SEC is already targeting them, right? Which is a much more significant deterrent than the class action. And the market is also punishing companies that have a restatement. So when you announce a restatement, your market price is going to decline by 10 to 15% in the usual case. So there's already a big sanction being dealt out by the market. Here we have the class action adding on to what is already a very public rebuke of the company. So, reform. Is there anything we can do to reduce the costs of securities class actions and maybe increase the deterrent value of securities class actions or securities enforcement generally? One option is to put enforcement exclusively in the government. We think government enforcement is pretty good because we know that SEC attorneys, Department of Justice attorneys, insofar as they have cases to choose from, well, the easy road is to go after the people that they really think have engaged in fraud. It's much easier to prove fraud against the fraudulent than it is against the innocent, because the SEC attorneys and the Justice Department attorneys are not driven by the size of the recovery, right? The size of the loss is not important to them because that doesn't affect how much they're getting paid. It's GS11, GS12, either way for them. They are going to focus on the most clear-cut cases of fraud. The downside is we think maybe they don't have enough resources, right? If we want more SEC and DOJ enforcement, that's going to require more tax dollars to fund it. That's tough to come by. Another option is to recruit the stock exchanges to police their listed members. They should have an incentive to be provide an implicit guarantee of the quality of the companies that are listed on them. If it's better to have good companies listed on your exchange and exclude the fraudulent. They have the appropriate incentives, but they don't really seem to want to take this task on. They haven't shown any interest. We could cut out the fiction of the class, right, the investors recovering for them, and we could just give the money to the plaintiff's lawyers. Less money, right? We just tell them, if you find fraud, we're going to give you some set amount of money if you can prove it in court. And that actually has something to be said for it, right? If compensation is not important and deterrence is the goal, set them loose to seek out compensation, seek out the penalties and impose deterrence. My idea is not quite that drastic. Pretty drastic, but it's not quite that drastic. It is to split the damages available in securities fraud class actions into two categories and to readjust how class actions work depending on what kind of damages are being sought. So if you want compensatory, all those out-of-pocket losses that you as investors suffered, you have to show reliance. You actually read the press release where they said that the company was going to come out with this new product in the next quarter and it was going to be super successful, that they were lying about it. You collect information about this company, and it influences your decisions. We're going to compensate you because we think that is a socially useful function, that it's good to collect information about these companies because it helps drive accurate accurate pricing in the stock market. It kicks out people like me, right? The passive investors who just buy the whole market and don't do anything to try and figure out which companies are good and which companies are bad. The alternative is disgorgement. We'll make the bad guys give up the money. Remember I said the corporation and the insurance companies, they're paying the settlements. That's where the money is coming from. The alternative is make the bad guys, the officers who were responsible for the fraud, made the misstatements, give back their gain from making the misstatement. Maybe they sold their shares before the fraud was revealed. Probably they exercised stock options. Probably they had some sort of bonus compensation that was tied to the company's stock price. Make them give that back, okay? The company, if they're not selling shares, there's nothing to take from them. So in this remedy, there would not be an action against the company. It would be against the officers. If the company's selling shares, back into the standard deal. Possibly provide the SEC with a role in screening these lawsuits. We have provided in the Fair Funds Act that the SEC can restore money to investors that it recovers from fraudulent companies and people and officers. We give the SEC an option to take over the lawsuits, coordinate this with the Fair Funds Act. The advantage for the SEC is that they don't face these large barriers to bringing the suit, the barriers that cause private lawyers to focus on the restatements and the enforcement actions by the SEC. So we can make it a little easier for the SEC because we're not as worried about the SEC's incentives in bringing the suit. SEC says, no, we're not interested. We don't think that that's a case worth bringing. Leave the pleading standards in effect. The disgorgement is going to be the usual remedy. We'll pay the attorney's fees of the plaintiff's lawyers, right? We're not going to have that big pot of money at the end of the day that we can give them a percentage of to compensate them, but we can pay them like we pay civil rights attorneys, right? We can pay them on an hourly basis for the work that they do, which provides some social benefit in terms of discouraging securities fraud. So that's a possible option to maintain their incentives. And potentially we can reduce the pleading requirement or the scienter standard if we've ratcheted down the damages to a more manageable level. Maybe we don't need to do as much screening as we do under the PSLRA. So I'm confident this would be less expensive for shareholders. That much I'm quite sure of. More precise, that we're going to target the people who have committed the wrong rather than the company. I'm also confident of that. Adequate deterrence, we don't know, right? It is a threat to company officers and directors that there is the possibility of being sued in a securities fraud class action. Maybe the directors exercise some oversight over the officers as a result of this threat. And remember, it has to be the threat on top of the threat of an SEC enforcement action. There may be some marginal deterrence. It's hard to say. My view, we should let the shareholders decide. Let them choose which regime they want. Do they want the current regime, which is theoretically based on compensation but doesn't actually provide it and is quite expensive? Or do they want a regime that is focused on deterrence? I say let the companies put it on their proxy, and the shareholders can debate and decide which regime they would prefer. And now you get to ask questions.
Part of the proposal is effectively one-way fee shifting, sort of akin to civil rights actions now. I'm wondering how you would feel about two-way fee shifting, or a straight-up loser pays rule.
I think two-way fee shifting makes sense under the current damages rule, that given the size and financial resources of the plaintiffs' firms, that that would not deter them from bringing these kinds of action. I worry about the incentive structure two-way fee shifting would work in this situation where the recovery is going to be a lot smaller, and the fees we'd be shifting would be the defense attorneys. And I don't anticipate that the insurance coverage for that defense work is going to go away. And we know that corporate executives like very expensive attorneys. And if there's the promise of making the plaintiff's lawyers pay, they'd go from liking expensive attorneys to liking them even more than they do. So I would be worried about that. Oh, could they get insurance for the risk of having to pay the fees of the other side? I don't think that there would be any legal impediment to doing it. I guess I would question whether you would have an insurance company that would be willing to offer it, because the function of the plaintiff's attorneys is to screen good cases from bad, and that the insurance policy might reduce their incentives to do that. So I'm not sure that an insurance company would be willing to offer that policy.
Just a real quick note, if you could wait for the microphone so we can get the recording.
Much of your argument is based on the marginal deterrent values, much of the argument to have any measure of securities class action lawsuit, which obviously brings to mind we want to equate somehow this marginal deterrence value or marginal benefit with a marginal cost. We can pretty clearly come up with marginal costs for this, but the marginal deterrence itself, how do you price that? How do we know that we need it at all?
Well, that is the difficult question. We don't know that we need it at all. Pretty much every other country in the world, save two, doesn't have this. So the positive argument would be, well, that's why our securities markets are so liquid and so deep, is because we have this and they don't. But it's not as if the markets in the UK or in the EU, that they don't have a lot of investors participating in them. So it's hard to look from the quality of the US markets and infer it's because we have this. You might just as easily say it's because we have a vigorous and active SEC, and I think most people who look at this say that we probably have the most vigorous regulator of any country. The UK probably comes a close second with the Financial Services Authority. So it could be attributed to that. Ideally, you'd like to be able to measure the deterrence, right? Unfortunately, the deterrence is so diffuse that it's benefiting all public companies and their shareholders that it's hard to detect any marginal effects, right? So we have the stock price reaction, but that's investors' hunches, right? They may be wrong about what the PSLRA did, right? What the plaintiff's lawyer said was that it was a license to lie, that it diminished deterrence. The investors seemed to be skeptical of that, or at least thought that the reduction in deterrence was worth it because of a greater reduction in costs. But the investors could be wrong about that, right? Because plaintiffs' lawyers get a lot of bad press. They certainly are portrayed by corporations as parasites. I think that's unfair and unwarranted. They are good lawyers, and the system is set up, and they work within the system, and most of them perfectly legally, as far as I know. So I think that they are providing some deterrence. I'm not sure how much. I would love to be able to measure it, because I'm in the business of trying to measure these things, but I don't know of a good way to do it.
Any other questions? Well, if not, if you guys can join me in thanking Dr. Pritchard for his, Professor Pritchard, I apologize, for his lecture. And a reminder, we'll be in 339 next week to discuss Cuban-U.S. relations, as well as the subprime slowdown. Thank you very much for coming. I often do that.
that we don't.